Good morning, everyone. Welcome to Wynne-Jones's IP in Practice webinar, Introduction to Intellectual Property. Before we get started, there are one or two housekeeping matters I'd like to discuss. Firstly, I have muted all attendees for speaking. I'd ask that you don't unmute yourself and submit any questions using the group chat that's available through Zoom. I will try and address any questions either during the presentation or at the end, and please feel free to ask whatever you think is appropriate. So, my name is Martin Hyden, and I am a patent and trademark attorney at Wynne-Jones. And today I'm going to talk to you about the basics of intellectual property and how this can affect your business. So in summary, we're going to talk about what is intellectual property, different types of intellectual property rights, patents, trademarks, copyright, database rights, designs, some discussion of trade secrets. We will discuss how you would use your intellectual property as part of a business, and finally, how you would manage intellectual property as part of a business. So moving on to the very first point, what is intellectual property? Essentially, this is the product of human creativity. This objective of creativity is what underlies a lot of these rights and property issues that we'll talk about today. And these come in different forms. There are inventions, which are typically new products or methods. They're new things, new arrangements, or new ways of doing things. They can be names, the labels or the other identifiers, the brand and the logo that you use to identify your products or services. There's the expression of ideas. It can be literature, graphic art, performance, music, those sorts of things. And finally, there's designed appearance, what things look like rather than what they do. So those are what you would generally call intellectual property. Intellectual property rights, or IPRs as you often hear them called, they're the legal rights that are created to enable these products of intellectual property to be treated by other property in law and in business. So these are the legal structures we put around these things because they are abstract in nature. The intellectual property rights define the activities to which the specific right apply. They'll tell you what falls within this right and what doesn't. They establish standards to say that this qualifies for some form of protection or does not. And ultimately, they are business tools. They're there to be used for essentially commercial purposes. There are some sort of non-commercial uses that can have an effect, but the principal reason for intellectual property rights is to manage these rights so that there is some form of commercial ability to use them. So let's move on and look at what the different types of intellectual property right are. And there are two main criteria. The first one is that there are a set of rights that require some degree of originality or creativity to establish the right. Those include patents, which are the original inventions, trademarks, the new mark or logo, copyright, the new expression, and design rights, which are the new appearance. Now, there are some other rights that don't require originality or creativity. And these are database rights, which are a variant of copyright, and trade secrets, which aren't actually intellectual property rights at all. These, as we'll discuss later, it's more about acquiring the knowledge rather than necessarily originating it. But we'll come and discuss these distinctions later, and we'll move on and discuss a little bit more about each one of these in turn and how they might work for you, what you have to do for them. So let's move on and talk about patents. Patents protect inventions. These are new things, so products or apparatus or compositions, systems, so something concrete, or they're new actions, so new methods of making things, new ways of doing things or using them. And so these are the actions of an individual that may or may not involve a new product. So it's not an either or, it's a both and. You can have patents for things and actions involving those things at the same time. Sometimes the two are very intimately associated. You can't separate one from the other, but that doesn't actually matter. The point is that we've got some sort of activity or some structure that we can put around there. And the concept of the patent is to give the owner of the right the ability to prevent anyone else from using that invention without permission. Sometimes called an exclusive right because it's the right to exclude. But what is very important to note is that a patent does not give the owner the right to perform the invention themselves. And the logic to this is that you can have patented inventions which are themselves subject to earlier patents. The example I like to give is that the first patent on the wheel might then have an improvement, which is a patent on a spoked wheel, which is still a wheel and therefore still subject to the earlier patent potentially. So a patent does not give the owner the right to perform, but what it does give the owner the right to do is stop anyone else from performing. That's what a patent is there to do. Patents last for up to 20 years from filing. So looking at a 20-year period, after that, anything that was in the patent then becomes part of the public domain. So what do you need to get a patent is the first thing. Well, it's all based around a written application at the Patent Office, albeit that this is now effectively done electronically, but it is a written procedure. And the patent application itself includes a technical description of the invention, the claims that define the legal scope of the invention, and these are really the minimum set of features that are necessary to use the invention. And you'll see them in various forms we'll talk about a little more later. The name of the inventor or inventors, the name of the applicant, and if they're not the inventor, how they got the right from it, and there are some official fees. That's basically what you need to get a patent. And every country will pretty much have that same set of requirements. Now, what can then happen is that the application is searched and examined at the Patent Office in question. And if there are objections, you have a process that allows you to amend and argue to try and get to an acceptable result. But basically, everything starts with a written document and a set of information and fees. So what sort of things can be patented? So we've said they're either new things or new actions, but whatever they are, the invention must be new, must not have been disclosed anywhere before the filing date. You'll sometimes hear this called novelty. So it can't just be new to you, it's got to be new in an absolute sense. But new, the originality standard is high in patentable inventions. There's also a concept of it being inventive. It can't be an obvious difference from what's known. It must be some level of difference that brings something new that wouldn't be evident to somebody in this area. And it's got to have an industrial applicability or not be an excluded subject. So industrial applicability is generally easily assessed. It's just got to have some possible use in industry. There are some areas that are considered not to do that, and this is typically one of the areas, for example, where should anybody try to patent a perpetual motion machine, it will generally be rejected as not industrially applicable because you can't actually use them. There's nothing you can do from them. But we've also got this set of excluded inventions. And these are very much about trying to establish a technical context for a patent or a public policy issue. So mathematical methods, numbers, just straight numbers doesn't work. Business structures are not patentable. Aesthetic creations, things that are interesting because of how they look, and we'll see other rights that could possibly help there. Surgical or therapeutic methods, this varies around the world. This is really a public policy issue as much as anything. Computer programs, again, we'll see that they turn up as protected in their expression in another way, and anything that's contrary to physical laws or just a discovery. So there are some things that you cannot protect by patent, even if they are new and unobvious. These criteria are judged by examination of the claims that I mentioned previously, this minimum set of requirements that tell us what the invention is. So that's what the Patent Office will look at. I'll take your claim, not your description, and look at that and say, is it new, is it inventive, and is it applicable? And novelty and inventiveness, as I've said, they're judged in relation to what we call the prior art, everything that's known at the date of filing. And the patent offices will establish this by searching. That doesn't mean to say if they don't find it, it's not prior art. But what it does mean is that often you will be having this discussion based on the results of a search that the patent office has done. And this is where you'll find some of the main activity in patenting and the process there. So moving on, that's patents. Now we've got trademarks. So a trademark is something that indicates the source of a product or service to a consumer in the course of trade. So it's an identifier, it's a source of origin marker. And these can be words, I mean logos, signs, patterns, sounds, animations, and colors. Which combination of these is registrable where does vary around the world. It used to be very, very static. It used to be words and logos. Now the laws are developing and to allow animations, sounds, music, those sorts of things. But basically, these are the things that you would apply to a product or a service so that they know where it comes from, you know, the originator, and also acts as some indicator of, you know, therefore some quality. And the right of a trademark owner is to prevent anyone else from using the same or a similar mark on the same type of goods or services in commerce. So there's some issues here. First of all, it's got to be, you know, the same or similar mark is fairly straightforward. Are they, you know, that's a simple comparison. But the question is, are they the same sorts of goods or services? So you can have the same mark in completely dissimilar services that are not affected by each other. The other thing to consider is that not all uses of a mark are necessarily commercial. There can be a normal use, a necessity to use these terms, even in the course of reporting or something like that. And commercial can be, you know, doesn't necessarily mean for money. It can be value in some way, charitable, that sort of thing. So, but it's about, this is where the right is. It's to stop somebody else competing in your area of trade with the same or a similar mark. Unlike patents, a trademark owner can use their mark on the goods for which it's registered. So somebody else could register the same mark in a different area of trade and you still wouldn't have any problem. I think one of the interesting issues we did see was when the Beatles created Apple Music, and then we had Apple Computer. Those originally seemed to be very different areas, music versus electronics. As we've seen, the domains have become closer and closer together. Then we start to develop the conflict later. So as you can see, something can start by being in a different area, and as trade and industry develops, they come closer and closer together. So what do we need to register a trademark? Unsurprisingly, a written application at a trademark office. This will need a sample of the mark. It might just be the word, it might be a copy of the logo, something like that. What goes with it is a list of goods or services. And there's an official classification that helps with this. So basically you say, goods and services are grouped by general types, and you generally register in a particular class or multiple classes according to where you're going. Again, name of the owner, the official fees go there. Offices can examine trademark applications. And again, there's usually the opportunity to amend or argue for official objections. But unlike patents, where we saw they were limited to 20 years from the first filing, you can essentially renew a trademark indefinitely. There are some issues about having to continue to use it, and still you have to pay for these things. But there are, it is essentially possible to renew them. And one example of this is the first trademark registered in the UK, trademark number 1, which was for Bass Beer, is still in force today. So it's been registered now for, I think, getting on for 150 years. So what sort of things can you register as trademarks is the first thing. Well, the point of the trademark is it's got to be capable of distinguishing your goods and services in the course of commerce. So it can't just be descriptive. You can't just say it's very good or first class or something like that. It can't, registering car for cars doesn't work. It can't be a common term that is used in the course of trade. And it can't be deceptive. You can't register as a mark that completely misleads someone as to what it is intended to do. So there are some inherent capabilities of marks that can and cannot be registered. Although, even though you might see some of these issues, these might become distinctive by extensive use. So even if it's not registered, the fact it's used a lot and becomes associated in the mind of the market can help to establish the fact that, yes, it is distinctive. So first of all, it's got to be capable of distinguishing. It can't be excluded. Again, we have a set of things that you cannot register, some protected symbols, so the Olympic symbol, Red Cross, royal arms, those sorts of things. It can't be obscene or defamatory, and it can't be anything illegal. Those relative, the legal sign is, there are one or two laws of countries that ban, for example, certain symbols. Obscene and defamatory occasionally comes up. And it must be different from other trademarks. So in the same way that you stop somebody who's similar to you, you can't get a registration of something that's similar to somebody else's trademark. Now, this may or may not be examined by a trademark office. They may not do it at all. They may just indicate to the owner of a similar mark that you're trying to register, and some may actually already raise objections and say, this is already registered, yours is too similar. So these are the registrable marks. As I've commented at the end, you can get unregistered marks as well, and they have rights. So these are relatively common. Most countries have some ability to protect rights, even if they're not registered. So let's move on now to copyright. Copyright is about protecting the forms of expression. So traditionally, this has been written works, books, screenplays, scripts for performance, those sorts of things. But in fact, it's any form of expression. And computer code, therefore, drops into this level of protection. It's considered essentially to be a written work. But artistic works, pictures and paintings, photographs themselves, stage designs, architectural designs, and musical works and dramatic performances, those sorts of things. It's all about expression. That's what it's there to do. And what copyright does is it gives the owner the right to reproduce the work or to make adaptations and sell copies. It's the right to sell copies, essentially. And the owner can therefore prevent anyone else making copies without permission, selling copies, that sort of thing. And the copy is considered to be a reproduction of something that's known as a substantial part. So it doesn't have to be the whole thing. It's a qualitative thing that to decide whether it's been copied or not. And as we've seen recently, I think in some music cases, it can often be a simple but very distinctive phrase within a piece of music that has been sampled, copied, or reused. So that's a very qualitative discussion, and it depends very much on the whole issue. So there's no absolute rule as to what a substantial part is, but copying is the first thing that has to happen. The important takeaway for copyright is that it does not protect the underlying idea. It only protects the particular form of expression. So this has been a case that we've seen with some literary works where people have created a scenario which has continued through a range of books. One might think of the Harry Potter books or something like that. But that doesn't protect the idea of a child wizard who lives under the stairs. So it's the particular set of words and structures that are put together. So that's copyright. So what do you have to do to get copyright? Well, the good thing about copyright is that it's automatic on creation of the original work. When the work comes into being, you have the copyright. There's no requirement for registration, although some countries do have a registration system which is useful for transferring rights, and should you ever need to actually enforce them at courts, it can be a very useful thing to have. The default is that copyright belongs to the creator unless there's another arrangement. So whether it comes in an employment contract or a specific commission that moves the ownership of copyright to someone else, if there isn't anything, it will belong to the person who created that original work. And the duration of copyright is long. It expires in most countries now 70 years after the death of the creator. So many works are still in copyright, even from, as you can see now, it's very routine to have works that were made available almost 100 years ago and still remaining in copyright. But yes, it expires automatically. You cannot extend beyond that date. You don't have to do anything to keep it in force. There's no registration or renewal requirement, but it does ultimately expire. And as with all expired rights, once it's expired, it goes into the public domain. So I'll quickly talk about database rights. In most of the ways they're treated, they're a variant of copyright. So the idea of what you can do, how you can stop people, the substantial part, and it's about copying. But unlike copyright, it doesn't require originality of the data. All it requires is some expensive effort in creating a database and collecting it. So the database right is not about originality of data, but about the collecting it together and organizing it, the activity there. It doesn't even have to be a new and original way of organizing the data. It can be created a known way of organizing data with some new data that's been pulled from known sources to create that. But the rights of a database owner are essentially the same as those of a copyright owner. And database rights are starting to become more and more significant as we do a lot more work via access through networks such as the internet, and pulling information and collecting it together and presenting it, making it available. So these are somewhat forgotten in many areas, but can be quite important, particularly for internet-enabled technologies and services. Finally, we'll start coming on to designs. Now, designs protect the appearance of products, what it looks like. So it can be 2D or 3D, and it can be shapes, and it can be the decoration or the ornamentation, the patterning on the surface, colors, the decorative ornamentation. The key thing is that a design is judged by how a product looks, not how it works. There can be no design covering a principle of operation. It doesn't care how it works or if it works. It's what it looks like that's important. And they're often termed industrial handicraft products. So these can be mass manufactured, or they can be individually, handmade, but to a repeating design. Or having very common design elements in there. But it's got to be reproducible. They can't be individual creations. Anything that's completely bespoke and originally crafted, you're probably not talking about design. It's got to be a repetitive process. And there has been some discussions to how many units you have to make to do that. But so, for example, a custom design for a house where only one is built is not a design within the meaning of the law. We talk about architectural things of copyright. Whereas if we've got a modular design for a petrol station that may be repeated many times, you may have a design that's appropriate there. And typically it can be simple individual articles. So there's no principal protection of the underlying operational construction. And it gives the owner the right to prevent anyone else making or selling without permission. So it's this common, I can stop you doing that. So those are designs. So what do you have to do to register a design? Well, unsurprisingly, we have yet again a written application. And it generally works around a set of drawings or pictures, or photographs showing the design. There are some formalities depending on where you are as to how they look, but generally you show the appearance. And it has to say what the product is. And there's an official classification that tells us what sorts of products are grouped together. So the design, while in registration has to identify what the product is, the rights apply to any product. It's just that you have to do that to define the class so you can judge for its registrability later, which we'll talk about. As before, we need the name of the owner and official fees. There's a possibility examination. Some countries will just allow you to register by payment of the fee. Others will actually look for, first of all, is it a design capable of being registered? And the other one, the most thorough ones, will look at other designs and look for some sort of originality. Again, the whole idea of amendment and argument, if you get objected, remains the same. And they can be quite long. They can last up to 25 years from the first filing in most countries. It varies around the world, In the UK and rest of Europe, we're talking 25 years. And this is pretty much a standard that's starting to develop now. So what are the registrable designs? It's the appearance of the whole or part of a product. So it doesn't have to be the whole thing, but it can be the lines and the contours, the shape, but it can be the color or the texture or materials of the product or the ornamentation. So for example, textile patterns are registrable as designs. Repeated textile patterning and fabrics. It's got to be new. It can't be identical to something that exists, and it can't differ in immaterial details. And what those immaterial details are not aspects of the design, but things that are not, they're present in the product, but do not affect the overall design itself. And it has to have what's called individual character. This is that sort of whole idea of it's got to be more than just different. It's got to differ in a way, you've got to produce a different impression on a user so that they can say, yes, I can see not only is it different, but it's clearly a different design. But you can't protect the features that must fit or must match another product. The things you need to connect together can't be protected by design. Those are functional, and generally you're looking at patents or something like that. Or in fact, indeed, features that are dictated solely by their function cannot be protected. It must be something that is, it has the choice of the designer to make it look like it does, and it's not forced on it by what it's supposed to do. As with trademarks and many other rights, you can't register designs that are contrary to public policy or morality, or that include protected emblems. And unregistered designs also potentially have rights, although they tend to be quite a bit more limited than registered designs. Moving on now to trade secret. Trade secrets aren't really intellectual property rights in the same way that database rights aren't. It's not about originality. There is a standard definition of a trade secret. So it's information, it's not generally known to the public, it has economic value to its holder because it's not known publicly, and that the holder makes an effort to maintain secrecy. And pretty much every trade secret law around the world has these 3 steps to it. So all you have to do is, and it can be, it's the information is there and it must have value because it's a secret. So it can be technical information, so process parameters, product designs, manufacturing process, that sort of thing. But it can be non-technical and often very valuably non-technical. So financial information, customer lists, supplier lists, pricing information, market surveys, all have a lot of value to a business. And often because if it's only known to them, that is a very valuable thing. So trade secrets is about the information and its secrecy and its value. As an example, you can have information that's secret but not valuable. For example, confidential personal information that a business might own. That's not a trade secret, although it is very confidential and is not to be treated any lesser way. But that's an example of material that is not commercial, doesn't have a value, but it is very important that it's secret. So it's about the value of the information. So what do you have to do to get a trade secret? Well, basically you have to generate or collect the information. So you either create some new information or you do some form of survey that brings together a new set of information that gives you something you didn't know before. So it could come from public or private sources. And a good example of this is a market survey. If it's the first time that anybody's sort of thought about whether it's the first time or not, doesn't matter. If you go away and collect this and bring it from disparate sources and bring together so you can draw conclusions, you may have value. So you have to generate the information. You have to identify its value. Why is it valuable? And that doesn't mean you have to put a price on it, but you have to see that, yes, I can see some reason why this is a valuable thing to do. And ultimately you have to keep it secret. So that means don't tell anyone outside your business. Anyone inside your business knows that it's secret and they have the same obligation to use agreements, non-disclosure agreements, NDAs, you'll hear them called, if you need to tell anyone else. You don't put this information into your patents because patents get published. And the question about keeping it secret, can products be reverse engineered? Because if they can, and you sell a product, then somebody can get access to that information. It's no longer secret and it's quite valid. So there are some things that you have to do to keep it secret, and those really affect how your protection is going to be judged. Because of this, it can last indefinitely. It's as long as you can keep something secret, then it has some form of protection under the various laws that operate in the country in question. I'm aware of at least one situation in the past that I've worked on. As far as I know, this thing has been secret since the 1950s. And it's in a commercial product, but it's something that you cannot get to. And everyone knows that it's very, very specific. It's not reverse engineerable, and it's very important to the performance of that product. So they can be very valuable things. They can be at the very heart of where the value of your product or your service lies. So we talked about some of the different types of IP. What are the things that you use them for when you've got these rights? One of the first points about using your IP is it secures the value of the results of your R&D and your business development. These are the things that tie down the effort you put in to making your business better. So your research and development into technical characteristics might result in patents. You may be the design, the new appearance is there. You're putting effort into creating that. Understanding your business development gives you some trade secrets. Expressing things, copyright, all of these are there to give you some control over what you've invested in your business to get it moving and the possibility to use it in a competitive fashion. So this is the collecting and securing your rights. Having done that, you can also use it as a deterrent to competition. Because you have secured your IP rights, the risk of infringement discourages competitors from entering the same market. If they do, you get a possibility to enforce through court should you be unable to resolve it. But by deterring competition, it allows space to scale up a business. By keeping the competition away from the area of interest where you're putting your effort, it gives you the opportunity to try and develop your business in that area with reduced competition and reduced impact. And ultimately, there's also the possibility of licensing. In other words, you allow competition, but you take some of the value there. Maybe it's not competition because it's not an area you're working in, but it has value there. So you can get extra revenue you wouldn't otherwise get. Or alternatively, it maintains your competitive position by allowing you to offer things at a reduced price because everyone else is paying license fees. So these are just some of the typical uses, and pretty much all of the uses will develop around these concepts. But very much the idea is that you secure your rights, therefore you've locked in the value, then you use them to establish your competitive position and try to extract the value from it. So we'll start to wrap up now and talk about the management of IP. So we've talked about what is IP, what the things are, and the various criteria you have to do to use it, and how you might get some benefit from it. But there are some key principles for a business to be able to try to get their IP working as part of their business. And the first aspect that really needs to work is that someone has to take responsibility for intellectual property. It doesn't work if no one is responsible, no one will do it. It applies pretty much to every aspect of business. But in the issue of intellectual property is that it is often an extra. It's perceived as an extra. It's something that you do after you've done the rest of your work. And so by making it someone's responsibility to do that, you move it beyond an extra and say this is part of our business. So in your, with very small businesses, there may only be, if it's only one person, this is very easy. If there are a few people, you just need to pick one. In larger organizations, obviously, there are some structures around it that work through management and implementation. But give someone the role of handling intellectual property if it's going to be valuable to your business. And pretty much everyone has some level of intellectual property. At the very least, you have your name of your business. And so you need to think about how you're using that and how it's working for you. Also, by giving it someone responsibility, it allows all of the other things to happen that we're going to talk about. So having responsibility for intellectual property in the management of a business is very important if you get the best value out of it. From experience, I've found that where this responsibility is devolved down to someone who is at a fairly low level in a business, tends not to work very well because there is then an inherent conflict. They have no ability to change things. It also tends to be given someone as an extra job on top of something else. So if you're managing a business, manage your IP much as you manage everything else. Next thing to consider in management of IP is strategy. It's an overused term, but ultimately, for an IP strategy to work, you need to identify where IP adds value to your business. So you need to develop the strategy that lines up, that says my intellectual property and the rights that I'm created are lined up with the value that they're creating to my business. And that's what I'm going to do. And then I need to make sure that that is aligned with my business strategy. As I said at the very beginning, the intellectual property rights are business tools. If your IP strategy is not aligned with your business, so it's not producing the tools that you need your business to develop, then you're not getting the best value from it. So absolutely need to have a strategy. It can be relatively straightforward and relatively simple. It does not need to be complex, but it's the alignment between IP and the business that's important. Where I've seen this not work, for example, is that if you take it with my previous point about responsibility, if that responsibility is devolved to someone outside the main business strategy area, and they continue to do what they've always done, the business develops a way, starts creating something new or working in new areas, and the IP is not protected there. A very good example I had was with a fairly well-known manufacturer of construction equipment, where traditionally they had protected their rights in the countries where a lot of the other manufacturers operate. But what they were finding was that, in fact, a large part of activity was coming from new countries, and these new countries had to be India and China and Russia, where they traditionally had not been very active and not been protecting very much. Their IP strategy was focused on the old world, and all of the activity was happening in the new world where they did nothing, and they'd not been updating their thinking as to say, where are the key issues going to be? Where are we going to need to do something? So like I say, alignment of IP strategy and business strategy is a key and essential activity as part of management of IP. It must be an obvious link between the two. And if they're not aligned, you either need to align them or change the activity. So moving on to strategy, we'll talk about budget. Everything costs. And IP is often one of the major individual line expenses of very small companies. Once you've got outside of salaries, these can be within businesses quite a significant cost. So you need to set a budget for dealing with IP. And to some extent, it doesn't matter. The first step is just to set the budget. How big that budget is the next question. But make sure it's something that you know and can have something to manage there. Now, ideally, this has got to be consistent with the resources available and the objectives. So you can't have a budget that's impossible to achieve because of your financial position of your business. But at the same time, you can't have worldwide protection of things if you're not going to pay for it. So you've got to balance this resources and objectives issue. Now, routinely, this means that your objectives have to be pulled back if you can't afford to do certain things, and it ties into the strategy. But there must be some consistency with saying, yes, we're going to do this level of IP work. If you don't, the consequence of that is you're going to have to make the funds available, which means you're going to have to budget for it. And it needs to sit there. The next thing to do is to stick to it. If you've set a budget, you need to run it in the same way as any other budget and use it effectively. Using the IP budget as just a sort of bit of spare cash in the budget to be used elsewhere is a way of killing your IP portfolio very quickly. So first thing is you need to say, yes, we can spend that and we should be thinking about spending it. But the other thing is that we shouldn't be overspending it. We need to be very careful about overspend. And there are some key issues there. One of the issues about budget is that costs in a lot of these activities take several years to mature. The initial cost may be relatively noticeable, but if you're working in multiple countries for over multiple years, these can be cumulative and they start to build up. And they can get to the point where you've individually, each thing is manageable. As a collection, they're very difficult to manage. So working within a budget is a very, very key issue. And as a result of that, you need to be prepared to drop older or lower priority things to free up resources for new IP. If your budget is being taken up by maintaining very old things that you don't do or make or sell or use anymore, then that's not working for you. The budget needs to be there to be managed. So that means that if you need to free up resources, you need to prioritize. And we're now in a situation where a lot of people are struggling with this. And the key is that they don't have any prioritization to say, while we're under budget pressure, what can we let go? We haven't thought about that. So budgeting is part of strategy as well. And finally, I'll come to the point of advisors. Unless you've spent a lot of time in intellectual property, a lot of these concepts will be new or fairly complex. Even if you know them well, actually implementing them can be very difficult. There are advisors, and I am one. Wynne-Jones is a firm of advisors, but there are many others around there who are here to help you do this. And the more they're used effectively, the more we can do for you. So I said involve advisors early and often. And the concern of that is this then becomes expensive. Well, the answer is you involve them early and often, and you let them know that there are limits on what's available and that they've got to work within these limits. As an advisor, I know that it's much easier to advise if somebody tells me I've only got X available to spend. What's the best I can do to fit with my, this is my budget. I will need to fit my strategy. How can I get the best out of that? And so, getting your advisors to help you is a very important thing. And don't be afraid to use multiple advisors, specialists for certain areas. Obviously using one can be helpful because it can help better understanding of the whole business, but there are some areas that are quite specialist and do need to do it. I haven't really talked about it in this presentation, but issues such as the tax implications can be very important if you have a very IP heavy and very international business. So let your advisors work for you and keep them under control. I mean, as a rights owner, you're there with the ultimate control. And you need to let people have the tools to help you. So those are the four principal areas that managing IP needs to address: responsibility, strategy, budget, and advisors. From my experience, at least one of these is always missing where I've seen problems. And sometimes all of them are missing. I think the responsibility one is a very, very common area. That is an easy fix. Strategy requires a bit of thought, but can be fixed quite easily. Budget and advisors are the two areas that probably seem to be the ones that are most problematic, especially for small businesses. As I've said, you need to set a budget, even if it's a very small one, and you need to let your advisors help you. And if your advisors aren't helping you and they aren't helping you meet your budget, then you need new advisors. At the same time, it's very difficult as an advisor to help if we're not given all of the information. So getting those two to work together can be very useful. And one of the issues about management of IP, I'll go back and talk about strategy, is that if you're considering, what is the IP strategy, it might be a relatively short-term one for a small and new business. It might be just to get to the end of the next year and some new investment. That might be all you're really aiming to do with your IP, as opposed to long-term dominance in a market. Again, so you can change these things, you can develop them, but you need all of these things to work together to get all of those. So with that, I'm going to put some conclusions. Intellectual property can contribute to the value of a business. I mean, it does, but left unattended, the value contribution can drop dramatically. Proper selection of the intellectual property rights to protect is essential. The answer is not always a patent. The value in your business may be your trademarks. That may be a very, very important thing, or the trade secrets, which are, as I've said, very commonly overlooked. So work out not just the overall contribution of value, but what the rights that you need to get control of that value. Costs can be high, and so active management is necessary. This is not to just do it once and then walk away. We don't need to think about it again. You know, the cost of doing something can be expensive. The cost of not doing something can be even more expensive. You know, especially if the value goes away, if competition develops, if businesses don't prosper. And that, you know, as advisors, we can help you set strategy and help you secure rights. And that's what we're here to do. All of the things that I have talked about today are subjects that Wynne-Jones can advise on. There are other advisors that can do that, and we're happy to talk about. So with those, thank you for listening. I'd invite any questions by text. I know that there are also some one-to-one consultations available on specific questions here, but I hope that's been useful, and I'll feel free to submit any questions, or alternatively just to contact me later. We have the contact details in the invitation. We'd be happy to discuss any of these things with you in future. So with that, I'm going to finish the presentation. Thank you all for attending, and please feel free to get in touch if there is anything else you need from us.
Oh, they've gone. Well, okay, that went well.
Okay, Rich, sorry.
Brilliant. That's it. Just left, isn't it? Yeah.
Yeah.
Yeah, I think perhaps they were just hanging on to find out when their one-to-ones were.
I've had some chat
Oh, have you? Oh, that's
from
fine.
Kailash and Xavius. Yeah, they both pinged me.
That's good. That's fine. I just thought everyone was sat there.
Yeah, I think they're just waiting. I just didn't want to end it straight away if we're doing a follow-up.
Yeah, perfect. Okay, well, we'll email the attendees then about their one-to-ones. But yeah,
Okay,
well.
I'll close this down now then.
Great. Thank
Well,
you,
Martin, that was
everyone.
really good. Really,
Thanks,
really
everyone.
good.
Bye.
Right.
Bye.
Thanks.
guys.
Cheers.